SJC-12028, Commonwealth v. Raymond Paquette.
Good morning, Mr. Frothingham.
Good morning, Chief Justice Gantz. Good morning, Your Honors. Tom Frothingham, representing Raymond Zachary Paquette, the appellant in this matter. And in this case, as you know, Paquette was convicted of 2 counts of violation of Chapter 268.13b for misleading a police officer. And it is our request that you would vacate the convictions and dismiss the charges because the use of this statute to punish Mr. Paquette is inconsistent with the intent of the statute, with the terms of the statute, and with precedent applying the statute.
But it's not inconsistent with the words.
Well, Your Honor, the words of the statute, and this is going to go back a little bit farther to the Rivera case, but since the amendment of the statute, the terms say whoever misleads a police officer.
Right.
It does not say whoever attempts to mislead a police officer. Prior to the amendment, the statute said whoever endeavors to intimidate a witness. There was no section criminalizing misleading a police officer.
Your client, I mean, surely the evidence was sufficient to suggest that your client intended to lie to the police officer, so the police officer would not be able to identify who else might have witnessed this crime, and lied so that he wouldn't become a witness. So you're saying, well, that's not misleading, that's just white lies, as you express.
I would argue that's withholding information, Your Honor.
By lying about it.
Well, however the information is withheld. If you look at the Morse case.
Let's assume for a second that this is the owner of the home where the stabbing took place, right?
It is the son of the owner.
I'm sorry, Mr. Peck.
The defendant is the son of the owner of the home.
Oh, okay. So this is the son. So let's assume, because the son said, I didn't see anything, and I don't know who did, that the stabber is able to escape the jurisdiction. Because by the time the police track down the other witnesses and now can identify who it is, the stabber is gone. Different case?
Yes.
Why?
Because
same conduct?
I would argue, in looking at the Morse case says that talks in terms of leaving the police in a situation which would be more disadvantageous than silence. The defendant has no obligation to talk to the police. He could say, sorry, I'm not talking to you.
Of course.
Then where would they be? They would be in the same position as the scenario that you just set forth. So I would argue he has not misled the police by withholding the information. And as the Commonwealth also argues that stymieing and stonewalling, but the classic stymieing, stonewalling, and delay would be to just not say anything. And there's nothing criminal about that. Mr. Paquette, simply because Mr. Paquette offers a clumsy statement
he lied.
lack
That's
of,
not a
of
clumsy
lack
statement.
of knowledge.
He lied.
Well, okay, but a clumsy avoidance of the proper way to withhold information from the police, which would be silence. So he doesn't know. He's not used to dealing with the police. This isn't a situation where there's gangs involved.
Well, let's assume that the victim died here, so this is a murder case. Does that make a difference?
Well, if Mr. Paquette's actions do nothing other than leave the police in the same position they would have been in had he remained silent, I would argue he has not misled the police. He is
I wasn't there.
And
I
he's
didn't
not
see it,
attempting
I
to
don't know who
mislead
saw
the
it.
I'm sorry?
I wasn't there. I didn't see it. I don't know who saw it.
Right. I would say that's I mean, you know, it's unfortunate. I mean, but you cannot force people to cooperate with the police. And if their conduct leaves the police in the same position, and that would have taken a matter of a couple minutes to say that. And I don't think that the police were, you know, first of all, the police never believed his story. So they never spent any time.
Well, of course.
But also getting back to my comment about the terms of the statute stating that whoever misleads the police, the Rivera case was talking about a witness intimidation and using the language prior to the amendment saying, we don't know why the legislature took the term endeavors to out of the statute, but we decide that has no effect with regard to the witness intimidation section. And they seem to talk about in Rivera, Robinson, Cassiano, when they talk about intimidation, they seem to be talking about deterrence rather than simply the literal definition of intimidation, which is inducing fear or timidity. So they say, well, we don't have to, the defendant doesn't have to accomplish the goal. When they talk about that, they're talking about deterrence, not intimidation. All that's required by the statute is intimidation with an intent to mislead, and it's when they say misleading the police, that shouldn't be carried over from the former language of the statute applying to witness intimidation to conclude that you don't have to mislead the police.
So,
Let's get to what the jury, you say, should have been told. I mean, I will put aside for now what, in fact, his attorney asked to be told, because I gather he got half. He asked for two things. He got one of them, and the second thing was the exculpating himself, and the judge said that's just a red herring. Nobody claims that he was seeking to exculpate himself, so I'm not going to give that. But put that aside for now. We'll get back to that. I gather that you're basically saying that the Morse, that part of Morse which says there must be affirmative misdirection intended to lead the police astray is what the jury should have been told.
Yes, Your Honor.
Now, what's the consequence of the fact that that's not what the attorney asked here?
Well, the attorney started along those lines, cited to Morse, and exculpating himself from liability. You don't know what the way this has been looked at from the trial court was from the perspective of the police officers. The police officers, I think the prosecution argues the police weren't investigating Mr. Paquette. Therefore, anything Mr. Paquette says could not be considered to have been said to exculpate himself from trouble with the police. But that's looking at it from the police perspective. From Mr. Paquette's perspective, maybe in the first interview, they're there investigating an event that happened at a party where there were probably lots of other activities that could have been prosecuted, such as underage drinking. And in the second interview, the police practically accuse Mr. Paquette of this crime. And so they, in that sense, what he's saying at some point could be considered exculpatory. So the prosecution, the defense did ask for a Morse instruction that an exculpatory statement is not criminal. But they did, I agree, they didn't quite get the entire Morse language into their instruction. But I think based on the discussions, that was the intent of their argument was to argue that he didn't lead the police astray and his statements don't rise to the standard required by Morse.
And what does that precisely mean? I assume it means, you say it means more than to say it led them astray in the sense that he claimed he was not a witness when he was. You're saying that's not sufficient.
Right. I'm sorry. I mean actively lead them astray, such as in the cases of Figueroa and Fortuna, where, take Fortuna, for instance, where there was a man who had suffered a gunshot injury and he had, I guess, stippling or gunshot residue on his jacket, and he claimed it was a gunshot fired at him from an overpass nearby. Now, the police can't ignore that. Even if they see the gunshot residue on his coat, they can't ignore the fact that he's saying there's somebody with a gun over there shooting at me. So they need to go investigate it. I would argue that not only is that an attempt to avoid culpability, but it's also statements that require the police to make another investigation, delaying their current investigation.
So I gather you're saying it caused them to pursue a course of investigation they would not otherwise have pursued.
I think that's a good way to put it. I think, false belief is one thing, but false belief, police are suspicious people. They don't believe anything. They don't believe the truth sometimes. So I don't know if false belief, but if you have to go out of your way, spend time investigating.
But why isn't that in some ways true here? In the sense of, at least for the first interview, the delay factor. So he says, I didn't see anything. And so then they have to do a whole lot more work to find out, well, what actually did happen when he had chosen to speak to them and then didn't tell them the truth, that
Right.
he did know.
I think I would get back to the point about silence, because
But he
you talk
wasn't
about
silent.
delay.
But he wasn't silent.
No, I know, but delay can be caused by silence. Delay can be caused by a misdirection, a false statement that actively misleads the police. So his lie about, first of all, it was a lie about something that was not central to the investigation. The police were investigating who attacked Mr. Spath. So whether Mr. Paquette is in the kitchen or whether he's outside picking up beer cans is irrelevant. The question is who hit. They're investigating something, and he's remaining silent on the point of the investigation
Well,
by claiming.
what if he says he did say, first, when they say, well, who do you think might have, and he says, well, Mr. Spath himself. And then he says, well, I could be wrong. What if he hadn't said, I could be wrong? What if he said, yeah, I think it's him. I think he hit himself over the head or whatever.
Well, I think that bit of the discussion between the police and Mr. Paquette possibly comes closer to actually making, blaming somebody else for the act. Now, that's possibly a false and misleading statement, but at the same time, this is a discussion between the police and Mr. Paquette, and he immediately, I don't really know. I walked into the room. Mr. Spath had his shirt off. I don't know what happened. I don't know whether he took it off and he started the fight. He immediately said he didn't know. He disclaimed and said he could have been completely wrong. So I would argue that statement immediately following this other statement is just simply another statement that he doesn't know, that he thought maybe this is what happened, but I don't know. So I wouldn't consider that to rise to the level of a misleading statement.
Let me ask you, the amicus brief draws a distinction between the first and second interviews with the police in terms of the exculpatory nature of what was going on. What do you say to that?
Your Honor, it's a little vague in my mind. I know that the amicus brief talked about how, I think in terms of whether a reasonable police officer would be misled, and I know they compared the first interview and the second interview on the basis of that if somebody lied in the first interview, and the police came back and asked them again, that the police know it's false already. They're not going to be misled by a repetition of the false statement. I don't know if that quite gets to your point, though.
Well, I just wondered whether you thought the distinction being drawn between the two episodes and the notion of a reasonable police officer as opposed to this police officer or these police officers.
I think that if considering the unit of prosecution, I think overall, and you can analogize. There's Commonwealth versus Gurney is a case that talks about perjury. They talk about time, the relationship in time between the two statements, the similarity of the two statements, the purpose of the investigation in which the statements were made. And I would argue in this case, they were pretty much all this. Although separate in time, the purpose of the investigation was the same, and the false statements were to the same degree. And I would argue that this should be considered one offense in that respect. And then as far as the reasonable police officer, the reasonable police officer, I don't think would have been misled by any of these statements. I think the indications are at the first interview that the police immediately, when Mr. Paquette opened the door, the officers testified that he said, what party or something like that. And immediately, then 2 minutes into the first interview, they're telling him that he needs to tell them the truth. So I would argue that would reflect on what a reasonable police officer would believe is that this was just simply a lie, but nobody believed it. But in any case, as far as the questions in the amicus brief, basically we would argue that you have to affirmatively supply false information, that the Commonwealth must prove that the police were misled by being led astray in the wrong direction, something not just stymied or stonewalled, and that the information must reasonably or mislead a reasonable police officer. And then, as I said, as far as the unit of prosecution, I would refer the court to the perjury case, Commonwealth versus Gurney, 13 Mass App Court 391, which discusses many of the same aspects that would be relevant here in determining a unit of prosecution, although in a perjury sense, which I would argue should be interpreted a little more strictly, because a lie is enough in perjury, whereas you require an effect on the police officer, which is unlikely to be present in a second interview with the same lies. But in any case, if there's no more questions.
Thank you.
Okay, thank you.
Good morning, Your Honors, and may it please the Court, Stephen Gagney on behalf of the Commonwealth. I'd like to state at the outset that Mr. Paquette had several choices here he could have made. When the officers knocked on his door 10 hours after Mr. Spath had been slashed, he didn't need to answer the door. When they asked him to speak with them about the incident, he could have said no, thank you. And once he chose to speak with the officers, if there was certain information he was not comfortable sharing or didn't want to disclose, he could have simply said, I'd rather not say. But he took the further step of actually weaving a tale, a false tale, a demonstrably false, content-laden fabrication that put him somewhere else at the time of the incident.
How did that mislead the police?
Well, there's no requirement that they be misled.
Well, just let me ask you, did it mislead them?
Under the statute,
Second interview, since they already had arrested somebody for the crime.
Well, at the first interview, again, we were 10 hours. We were in the very nascent hours of this investigation, the most critical part of the investigation. And rather than have perhaps the key percipient witness to the crime who could provide a prompt identification and assist the officers in apprehending this person, they were left walking away from Mr. Paquette's house with very little information, in fact, some misinformation about what had happened that night. And in the early stages of an investigation, what happened is obviously central, but who knows what and who the witnesses are is just as important. In fact, that's how you actually solve a crime. You work your way inward.
Would it be just the same, do you think, if he had said something that he said the second time, but I was blackout drunk, I don't know what happened. I didn't see, I was in the room, yeah, but I didn't see squat.
That would have been much harder for the Commonwealth to disprove at trial. And this would perhaps bring the case more into the Morse realm, where a person says, I really don't remember, I was drunk, I can't say for sure. Those are statements that are very hard to be objectively disproven by other evidence. Here,
Wait, we're not talking about perjury. I'm trying to figure out, why is that misleading? I mean, why is that more or less misleading?
well, again, this goes to what the definition of misleading is. And under this court's definition from the Figueroa case, to mislead can mean as simply as knowingly making a false statement. And I would admit that between Figueroa in 2013 and the Morse case, more recently, the definition of mislead has become less clear. Because under Figueroa, simply making a false statement or withholding information and creating a false impression itself was sufficient to prove misleading. Now, in the Morse case, there was language in that decision which seemed to suggest that more was required, specifically an intentional act calculated to lead another person astray or intending to lead the investigators off course or misdirection and actually affirmatively sending the officers down the wrong path. But that's not strictly what's required under Figueroa and under the words of the statute.
In Figueroa, that indeed was what happened. He basically said, I was at the Alcohol Anonymous meeting and I was not taking the kids out for Halloween. So there was affirmative misdirection there in Figueroa. The issue wasn't raised in Figueroa. It was raised in Morse.
Well, under the language of the statute, where the intent required is to impede, obstruct, delay, or otherwise interfere with the investigation, a person can do that without actually misleading the police or sending them on the wrong course. Hypothetically, say, if during this argument a fugitive ran into this courtroom and ran out that door, and 30 seconds later an officer ran in and asked me, where did that person go? Now, I could say nothing. I could say I'd rather not say. If I said he went out that door over there, I'm misleading the officer.
Right, but
What if
that's
you said, I don't know,
What
even
if
though you
say,
did
yeah,
know?
what if you say, I saw
If I said, I don't know, I didn't see
Nothing.
anything,
Yeah.
and then later the officer pulled surveillance video and actually saw me seeing the person, that would be a false statement, and that would be delaying the investigation. But if I put my hands in my pockets and said, well, gee, that's a really good question, let me think about that, all the while delaying the investigation, allowing that person to get farther and farther out of the building, I am delaying the investigation without necessarily misleading the officer.
Okay, so in your mind, let's take the typical shooting, the barbecue, 10 people who are there, somebody gets shot, 8 people say, I saw nothing. In fact, it turns out they all saw something. They're all guilty of this crime.
Well, I think that raises a fair point, which is technically, could the Commonwealth perhaps prove that they violated the statute?
Let's
And
assume they
perhaps
can.
technically they
Let's
could.
assume they would do it the same way here. There would be 3 other people who would say those 8 people saw exactly what happened, and they're lying when they say they did not. They just didn't want to get involved. I had the courage to get involved. They did not. They're lying.
And again, this goes to the point between, the distinction between perhaps a person's motive and a person's intent. Now, a person can obviously have the motivation, the desire not to get involved or to protect their friends, but that's not necessarily what the statute's talking about. It's an affirmative intent to delay, obstruct, or harm the investigation. And in this case, it was not simply Mr. Paquette's denial of information or knowledge which led to his conviction. There was additional evidence of his intent in this case, an affirmative intent to mislead the police. If you were only looking at a person's statement and nothing more, it can be very difficult sometimes to meet that second element of intent to mislead.
But I mean, don't I intend to mislead the police when I essentially am thinking, I really don't want to get involved in this case? I'm frightened. I live in a community where there's abundant violence. I really do not want to be called a snitch, and so I'm going to say I saw nothing. And you can prove that to be a lie. Are all the people who are thinking that, who say they saw nothing, in violation of this crime?
I think the statute could arguably fit that, but I think what's telling is that this court, and to my knowledge, the appeals court, hasn't seen a rash of cases where the Commonwealth and the law enforcement authorities are prosecuting people simply for being afraid. In this case in particular, Mr. Paquette, rather than being charged or indicted after the first interview, the officers went back a second time. They gave him a second chance to come clean and share what he knew.
But
And
then he
even
was
in this,
almost being accused of impliedly, violating this statute. And so why wasn't he then really trying to just exculpate himself?
well, even after the second,
I don't understand why the police come back a second time to do the same thing.
When
When
they
they've
have
already
already-
made the arrest.
well,
It has nothing to do with the original investigation at this point.
respectfully, I strongly disagree. Just because an arrest of Mr. Bousquet, the slasher, was made in this case hardly means the investigation was done. Investigations don't end
All
when
the
it
other witnesses were interviewed.
It is routine for officers to go back and re-interview people perhaps a second, perhaps a third time, and then to summons them perhaps to grand jury. And in fact, in this case, the record evidence is that after Mr. Paquette did not tell the truth the first time, the officers went back a second time and tried to make it crystal clear that he may be digging himself a deeper hole. After that second interview led nowhere, the record evidence is, and this came out during sentencing, Mr. Paquette was actually summoned to testify before the grand jury. And on the day he reported to the courthouse, he was given yet a third opportunity to come clean, to contact the officers, and to tell what we, at that point, were very firmly convinced he knew.
Well, don't you get the sense that the police are trying to position Mr. Paquette to be charged under this statute? I mean, that's how it feels to me, and I just worry about that because you'd have to be pretty sophisticated, even under your suggestion about what people are supposed to say or how they should interact with the police. I mean, given your interpretation of the statute, you'd have to be pretty sophisticated to avoid being charged. Wouldn't you agree? And not everybody's sophisticated and have the intent to do what the statute is saying that they're doing here.
Respectfully, I don't think a person needs to be sophisticated first off to tell the truth or
Well-
to remain silent, to not lie, essentially to not make a false statement.
Well,
Or
it
to
gets
not
back
withhold
to Chief
information.
Justice Gantz's question. I mean, are we saying that whenever you talk to the police, you have to tell the truth, or else? That can't be right.
Well,
Well, this is certainly not 18 U.S.C. 1001, false statements to a federal officer, right? This is something different than that?
yes, it is.
Okay. Well, in going back to the point being made here, in addition to a false statement, you also have to establish that it was made with the intention to impede, obstruct, or interfere with the investigation.
Absolutely.
And I think you would be hard-pressed to prove that in a case where it was a barbecue and there was a shooting and everybody said, I didn't see nothing.
Putting aside for the moment the fact that I think we'd be hard-pressed to find instances where the police are actually cracking down on those people.
Well, that's not the issue.
yeah.
The
The
issue
intent to
exactly
protect
is
oneself is
a
a little different than the
a
intent.
specific intent to impede, obstruct, delay. And in this case, on the facts of this case, I'd suggest there was ample additional evidence, apart and aside from what Mr. Paquette said or didn't say, that he harbored that specific intent.
What was that?
Starting on the night of the incident itself, as Mr. Spath is getting into his vehicle to go to Cooley Dickinson Hospital, holding a towel to his neck, Mr. Paquette comes out of the building, knocks on the window and says, "You weren't here, nobody saw anything."
And that's criminal?
No, I'm not
Of intent.
I'm not suggesting that's criminal, Your Honor. I'm suggesting that goes to his intent. That's reflective of his state of mind and his efforts to keep this entire matter hush-hush and to delay and thwart the investigation, in fact, before it even started. Secondly, when the officers knocked on his door the next morning, despite the fact that there'd been a bottle smashed in his kitchen, blood on the floor, and he had told people to remain quiet, when confronted about the incident, his response was, "What incident?" essentially playing dumb. Third, during the interview, he repeatedly says, "I didn't want this to happen, didn't want the police to come to my house. The last thing I need is this." The intonation in what he's saying about his thoughts toward the police. The fact that he's shifting gears dramatically during these interviews, saying, "I'm crystal clear I was in the backyard," but then when that lie is starting to unravel, he says, "Oh, I was blackout drunk, I don't remember a thing." He's shifting horses. And fifth, Mr. Paquette in this case had an affiliation, if not a friendship, with the assailant himself, Mr. Bousquet. So here we had surrounding and additional circumstantial evidence from which the jury could infer not that he was just afraid or reluctant or scared, but that he actually harbored an ill will toward the police and their efforts to investigate this crime. So in this case, we had more than just a, "I don't know anything."
I'm sorry, so if I am impeding the investigation by saying I didn't see something even though I did, because I'm afraid, that matters?
No, it's specific intent, as the jury was
Right,
charged.
but I do intend to impede, I basically know something and I'm withholding that information.
For purposes of impeding the investigation?
If the intent is to impede the investigation because one is scared, or because one is afraid, or because one just wants nothing to do with the police, it's not the because that matters. It's does the person intend to delay or obstruct or impede the investigation for whatever reason.
Is there a difference between impeding and not helping?
Oh, absolutely,
And
absolutely.
Okay, so
If a person-
wasn't that what Mr. Paquette was doing?
Well, Mr.
Not
Paquette-
helping?
Mr. Paquette could have easily said, "I don't care to help you, I have nothing to say to you, please get off my property," or just sat there with his arms folded. But he took the affirmative step to lie, to provide the officers with false information.
So
And that's not just being not helpful, that's actually being detrimental to the investigation.
Let me ask you this. If somebody's arrested for murder, and they are given Miranda warnings, and they say, "Yes, I want to speak to you," and they tell this wonderful tale that ultimately the police determine is not true. So they get not only murder, but violation of this statute too? So everybody who doesn't tell the truth in speaking to the police, if they are the defendant, gets charged with this also?
If a person's affirmatively telling an elaborate tale or laying out facts or allegations that aren't true, absolutely. But if a person simply says, "I didn't do it," or "it wasn't me," particularly if they're the accused, then I think we're closer to the Moore situation and a person simply trying to exonerate themselves.
There you go back to the sophistication that I'm talking about, that, you know, who's going to know that they have to say, I don't want to talk to you, go away. But instead, they do what normal human beings do when they're talking to the police. And they get snared by this statute for their lack of sophistication in answering the questions.
Again, Your Honor, I just respectfully have a different take on it. I don't think you need to be that sophisticated not to lie to the police and to do so with the intent to impede the investigation. And I make no qualms about that. They are two separate elements. Simply proving someone lied does not constitute a violation of the statute. It is the specific intent to have that detrimental effect on the investigation, not necessarily to lead the officers through the wrong door, but simply to delay them, obstruct, impede, or otherwise impair the investigation.
So in this case, let's go to the second interview. Second interview, they go and essentially say, you weren't telling us the truth, fess up, you lied to us beforehand. If it had turned out that he had said, you're right, I was trying to protect my friend, I'm sorry, I saw the whole thing. He's still guilty of the crime, I gather. He just has confessed to it, correct?
He'd still be culpable for the first statement that he gave 24 days earlier.
So that means every time the police have somebody who said something that was exculpatory of a defendant, and then they go back and they say, I was scared, I'll tell you the truth now, they are confessing to a crime, and the Commonwealth should be informing them that they are now confessing a crime when they tell the truth after they had lied?
Although, Your Honor, I see my time's expired, but if I may finish,
Yes.
answer your question. Although technically, yes, the person would have still violated the statute during the first interview, as a practical matter, and being on the ground, I can tell you that that would not happen, and that would not have happened in this case. Mr. Paquette would not be before this court today, nor would he have been charged.
Discretion rather than how to construe the statute, isn't it?
There is discretion in how to apply it, and
Well,
against whom to
You're saying,
apply it.
don't worry about it because the prosecutors would never do it.
I think it's very telling that this court hasn't seen instances where it's being applied on trivial matters or arbitrarily. In fact,
And we actually do have some cases, but apart from that, is it a promise, reward, and inducement then, when that person goes to trial, that the Commonwealth did not prosecute that person for the crime? That the Commonwealth made a prosecutive decision to not do that? Is that something that has to be disclosed to defense counsel?
well, the fact that the Commonwealth,
Basically,
In its
they have a key
discretion-
witness, who's told them a lie initially, and then said, I'll tell you the truth, this is what really happened, and that person's testifying as a key witness for the Commonwealth. Is that now a promise, reward, and inducement that the Commonwealth must give over to the defense, that we exercise our prosecutive discretion to not prosecute that person for this crime?
I would say no, Your Honor, because before the person came clean and told the truth, if the Commonwealth said, if you tell the truth, we'll give you a pass on the first time, induced or made a promise to get that second statement, then yes, it would be disclosable, it would be a promise, reward, or inducement. But if, in the Commonwealth's discretion, it chooses not to apply a statute where it arguably could, that in itself is nothing being conveyed to the person or being used as an inducement to get that second statement. And I can tell you, in this case, as the prosecutor who was involved in this investigation from those early morning hours on May 4th, to the prosecutor who met with Mr. Paquette when he came into the grand jury, as the prosecutor who indicted Mr. Paquette, I can tell you that he would not have been charged had he fessed up, either at the tail end of the first interview, or during the second one, or when he came into the grand jury.
Suppose he told the truth at the grand jury. Because he was under oath, knew he was under oath, completely different circumstances than when he's talking with the police. So doesn't that, if he tells the truth before the grand jury, doesn't that provide proof that he has twice lied to the police?
It would in theory. I can tell you that grand juries often use as exactly that opportunity for a person to come clean and disavow the previous lies that they've
Doesn't
told.
that serve the purposes of the investigation? The grand jury testimony, the truthful grand jury
Yes,
testimony?
absolutely.
Right.
All right, thank you.
Thank you, Your Honors.